All right, good evening, ladies and gentlemen. For those who do not know, my name is Matt Green. I am president of our local Federalist Society chapter, the Brevard Hand Alex Howard chapter. Tonight we are hosting Mr. Deroy Murdock. Very excited about hosting him. I'll briefly tell you all a little bit about our Federalist Society, and then what I thought is I'd hand the dice over to Mr. Quinn Hillier, who made tonight's guest possible to give us the speaker introduction. For those of you who do not know, the Federalist Society is a nonpartisan, conservative, and libertarian organization dedicated to freedom, federalism, and judicial restraint. It is founded on the principles that the state exists to preserve freedom, that the separation of powers is essential to the Constitution, and that it is emphatically the duty of the judiciary to say what the law is and not what the law should be. So tonight, in that vein, we are going to host Mr. Deroy Murdock. And Deroy will be introduced by Quinn Hillier. Quinn has a long-standing relationship with Mr. Murdock, and I'd like to thank Quinn for helping make tonight's event possible. And I won't go on any further. I'll go ahead and call Quinn up so you can do the introduction. Here you go. Put that on your tie.
Okay. This is going to be just a slightly longer introduction than the usual one, but I'm delighted that we can bring Deroy Murdock down here. My freshman year at Georgetown University, we got there on a Friday afternoon, and on the first Sunday morning, I go down into the cafeteria, and still, you know, you've only been there a day and a half, and you still don't really know people, and you can't recognize the faces, or you don't put the names with the faces. But I see a guy sitting at a table. You know, I've got my horrible college cafeteria breakfast slopped on the tray, and I sit down and I say, I think you're on my dorm floor. Are you First New South? And Deroy Murdock says, yeah, hi, Deroy Murdock. And I say, hi, and I introduce myself, and I sit down, and he's got a Washington Post, and not knowing what else to say, I say, so what's in the Post this morning? And he says, oh, a bunch of liberal junk. He says, this paper's so liberal, I just can't stand it. And I said, I think I got a friend. And sure enough, we had 4 great years of Georgetown raising heck in a conservative way. Both served on the board of the Young Americans for Freedom there. Both wrote for the college paper there. And ended up, both of us went into journalism. And for decades now, we have traded columns back and forth before they're published, just for one more quick set of eyes. Deroy, does this word sound okay? I'll email him, and he'll email me back, and vice versa. And Deroy, and I'll tell you a little bit about him professionally in just a moment, but I also don't want to raise expectations too much, but this is one heck of a speaker you've got. I've been listening to him speak now for 32 years, but I think my favorite memory of Deroy speaking was there was a debate on Georgetown's campus about how to deal with South Africa and apartheid. Now, of course, everybody was against apartheid. The question was, what do you do about it? Do you completely divest, or do you do what was known as the Sullivan Principles, which were where American businesses would go in, but they would insist that within at least their factories or their plants, that they treated everybody equally and fairly, and they had all sorts of good human rights policies. And if companies would abide by the Sullivan Principles, then the thought of some of us was that would actually help open up the society and towards needed change. And so, of course, that was a minority position on campus. Georgetown not maybe being as liberal as Harvard or Dartmouth, but still a reasonably liberal campus. And you know, they were having shanty towns out on the lawn to insist on divestment. Well, the debate's going back and forth And Deroy tells this story, a true story, about how on the border between South Africa and one of its neighboring countries, I forget which one, there is a fence. And it is a heavily guarded fence. And it was not a fence built by the South Africans, but built by the neighboring country. And every year, a horrific number of people died, killed by the guards, trying to escape through or over the fence into South Africa. Into South Africa. And when Deroy says this, I swear I thought there was going to be a riot. I mean, the left-wingers in the crowd, which were most of the people in the crowd, started yelling and screaming and just, I mean, people were running for the microphones and grabbing the microphones and wanting to yell at him, and Deroy stood there placid as could be. And he said, when he finally was able to find a moment of semi-silence, he said something along the lines, I don't remember the exact words, were, people don't want to escape into South Africa because of apartheid. Apartheid is terrible and must be changed. But some things are worse. And at least when you have economic freedom, or at least partial economic freedom backed by the rule of law, that offers hope, and it offers the basis of civil society, and that can be something to escape into if you've got something worse. And he was absolutely right, and it was brave of him to say it with all these people just going ape, yelling at him, but he stood his ground and did it with a smile. And I thought of that now because his point, again, was of economic freedom and of the rule of law. And that is what Deroy is going to be talking about tonight, one aspect of the rule of law, serving on, in this case, New York juries. And with that said as background, professionally, Deroy is a Fox News contributor, a media fellow with the Hoover Institution at Stanford University, a senior fellow with the Atlas Economic Research Foundation. His work appears regularly in the New York Post, the Washington Times, the Boston Herald, the San Francisco Examiner, and National Review Online, where he and I both serve as contributing editors. He has an undergraduate degree from Georgetown, an MBA from New York University, and his introduction says that Deroy hopes that someday the free society will bring him and every American more leisure time to experience fine dining, motion pictures, skiing, live music, and the priceless joys of friends, family, and loved ones. With that, I give you Deroy Murdock.
Quinn, thank you very much for that very kind introduction and that wonderful walk down memory lane. I appreciate that very much. It's been a joy knowing Quinn Hillier for the last 32 years, but who's counting? Really, actually feels like about 30, I think. Feels more like about 15, I think. And so it's a joy to be here with you. And I'm actually in honor of our alma mater. I'm wearing the Georgetown blue and gray tie. These are our school colors I'm wearing. So it's great to be here with you. Great to be here as well with Mrs. Quinn Hillier, Tracy. Where's Tracy? There's Tracy right there. My first time in Mobile was back in June of 2002, when I was very happy to attend their wedding here in Mobile, and I've not been back since. It's great to be back. And we had a nice time last night enjoying the azaleas and the beautiful live oaks and all that, and had a wonderful dinner at Kitchen on George, which is delightful. And we enjoyed the duck confit spring rolls, which I highly recommend. Those are wonderful. And it's a joy here to be here with Tracy's parents, Mr. and Mrs. Robinson. So great to see you here again as well. I want to say thank you to Judge Green for making this experience possible. We also had a very nice time today. He taught me a new word, which I'd never heard before, which is scalabamorinico. I've got the L's and the C's interposed. That's it. Slacko Bama Rimiko. Anyway, it's not easy to say, but I learned it. And we had a very nice visit to Joe Kane's grave. So that was very educational. It gave me a real sense of the history of Mobile. We also went to Wenzel's Oyster House. It was a very enjoyable place. We had a very nice lunch there, and I had a real kick looking at all the little signs and sayings up on the walls. And I think you might appreciate this one, which is the GOP wonders what to do next. Let's see. How about all holding hands and coming up out of the shelter together? I think that's pretty good and very timely advice even today. Also want to acknowledge the presence of a gentleman by the name of Jack Dunleavy. Where is Jack Dunleavy? There he is in back. Just had the pleasure of meeting Jack this afternoon. Jack Dunleavy not only is a World War II veteran, but he actually was in Tokyo Harbor on the USS Missouri when the Empire of Japan surrendered to the United States of America in 1945. So it's great to be here with you, sir, and thank you very much for your service to our country. And thanks to all of you for being here tonight. I know you all have other things you could be doing with your family, your friends, your loved ones, and those of you attorneys probably have some legal briefs to work on and so on, but here you are spending the evening with me and talking about public policy. So thank you very much for being among the few, the proud, those who give a damn. So today my topic is I, Juror. This is the jury ballot from my last term of service as a New York City juror. And I'm going to talk to you about my 4 instances as a New York juror, the 4 cases in which I served. And you're probably surprised to see somebody who is a journalist being on 4 cases. In fact, I have done those 4. And that's a reflection of something that we've tried to do in New York City over the last few years, which is trying to get a broader and more universal set of people to come into the jury system. In the past, there were people who automatically were exempted from service, or almost automatically would walk in and hold up their hands and say, I'm an attorney, I'm a cop, I'm a doctor, and they'd right away walk off and not have to serve. And a lot of people had all kinds of little tricks and games they played so they wouldn't have to do jury duty. The thought was, look, rather than have that happen, have a relatively smaller number of jurors, let's expand the pool as much as possible. No more of these automatic exemptions. Everybody's got to serve, but rather than show up every day for about 2 weeks trying to get onto a trial, you show up, and if you're not seated on a jury within a couple of days, you're excused and you can go back and you don't have to return for 4 years. And a lot of people consider that more fair. People are not playing as many games to try to get out of the system. And people know that unless they're put on a trial, it won't take more than a couple of days of their time to be involved in this. And as a consequence, you have all sorts of people participating as jurors. In fact, it's kind of funny to see the kind of people who actually have served in this more expanded system. This is a case from, I believe, about 2 or 3 years ago. And that juror right there is none other than former Mayor Mike Bloomberg, who actually did 2 days of jury service. He sat in the box and went through voir dire like the other jurors. After 2 days, it turned out he was not put onto a case, so he was excused and went back to City Hall to do what he did as mayor. And then back in 1989, we have this gentleman here, Rudolph W. Giuliani, who actually was put onto a jury. Because he was juror number 1, he was, by luck of the draw, the foreman of the jury. And so he served on this case, and they actually rendered a judgment on a $7 million personal injury case. So even the sitting mayor of New York City was in the jury box. He'd come in, do his jury duty, and then go back to City Hall and go about the business of the people of New York. So in this new system, pretty much everybody participates. And when you do your jury duty, you start off here. This is the New York City Supreme Court building. We have a funny situation in New York State, which is we refer to our state trial courts as the Supreme Court. That's not the big Supreme Court. That's called the Court of Appeals. So if you hear something happen in New York Supreme Court, it doesn't necessarily mean that that's the last word. It's actually the first word. So this is our big, beautiful Supreme Court building in New York City, right downtown, just a couple blocks from City Hall. And you walk in there, and that's where you begin your jury selection and so on. And that's where I went in the very first time I did the first of my 4 cases. And that was about, I forget the exact time, but probably sometime in the late 90s, I think. And before I went in, I expected the following experience. I expected to walk into New York City Court and for something to be like The Paper Chase, that the TV show, and before that movie starring John Houseman, as this very debonair, suave, extremely well-educated and elegant lawyer standing before the jury and talking about the law and justice and presenting the facts and the evidence and having this very high level and uplifting kind of appeal to us. That's what I expected. Well, what transpired was much closer to Cousin Vinny. I was absolutely astonished. You know, the lawyers would come in and say, "Can you be fair on this case or what?" You know, that's the kind of presentation. And they went back and forth and sniped at each other, and it was, I would not describe it as particularly elegant or terribly polished. You know, did you say Utes? You know, this is the kind of experience I had in my first time that I was in the jury system. Really quite astonishing. So I thought what I would do today is talk a bit about the cases on which I served, what lessons attorneys here and judges and possibly potential jurors can take, and then some personal observations on what I think about, what my thoughts are having experienced this situation. So let's talk first about these cases, what actually happened in the courtrooms and what what I actually saw unfold in front of me. The first case was the Cousin Vinny case, as if you want to use that term. This is the case where we finally sat down after these attorneys all yelled at each other back and forth. We finally got 12 of us seated and a couple of alternates, and the judge said, well, ladies and gentlemen of the jury, we'll begin the trial tomorrow morning at 9:30. Please be here on time and we'll begin the proceedings and so on. So I went home and was very excited to come in and experience the trial and all that. Well, we came in, we sat down, and the judge said, ladies and gentlemen of the jury, it's my duty to inform you that between when you were seated and now the parties have settled the case. There is no more dispute between them. So thank you very much for your service. Case dismissed. He banged his gavel. We all looked at each other and said, is that it? And that was it. And off we went. So in that case, it was settled overnight and we didn't have to do anything else. So that was pretty easy. Well, a few years later, they called me back another time. And this was a civil case in which I was seated. We did proceed to trial. And it was a personal injury case, specifically a medical malpractice case. And I must tell you, it was not pretty. It was actually a very ugly case and a very unpleasant case, but it was a very interesting case because the injury was a botched abortion. And this poor woman was in the courtroom because, according to her, she had had an abortion and it was not handled very well by the doctors, and she was suing under personal injury because of the damage that she had suffered. And according to her, what had happened was she was in the surgical room where the procedure was being done, and the doctors were not using a particular ultrasound device, which would have made it possible for them to have done this, I assume, more smoothly than they actually did. They used the device which was used to do the abortion, punctured her uterus, and she was damaged because of that. She said she had all sorts of trouble conceiving afterwards. She had pain during sex and all that, and she was really in considerable distress. And when she testified, we all felt quite sorry for her. The defense attorneys, or single attorney defending the doctors said, well, in fact, the device that they talked about was something in possession of the practice, that this therefore meant that they were not negligent and that they did what they had to do and were abiding by all the proper and expected procedures in this case. We heard the testimony, went back and forth, and I'll get into some of the specifics later, but eventually we determined that the defense did not present all the evidence to get past our reasonable doubts, and we went back into the courtroom and we decided that, in fact, we felt very sorry for the lady, but she didn't prove her case, and we wished her luck, but she walked out of there without a penny, nothing. There was no negligence, we determined, on the part of the doctors, and so she went home empty-handed, and her lawyer was very frustrated, of course, by this result, but we thought that was the just thing to do under the circumstances. So that was the second case. No award to the plaintiff. The third case also was a civil case. It was a very interesting case and very unusual. It was a case of defamation of character. I don't think you see too many defamation of character cases in the courts anywhere. And when they put together this case, I thought I'd be the last person they'd want on this case, since defamation of character often has to do with things like people's reputations in the press, how the media handle things, et cetera, and so on. And I thought certainly the last thing I'd want is a journalist who might know how this law works and be able to second guess what the lawyers were saying. Well, I sat down during voir dire, they looked at me, they looked quite excited, and they said, yeah, we want you on this case you're on, and lo and behold, I'm suddenly on this case, and so they didn't reject me, they in fact put me onto this jury. The case is a very interesting one, and involved a young man of about 38, 39 years old or so, who was a drug counselor. And he worked at Harlem Hospital, which is a city-owned hospital in New York City. And he was a drug counselor, dealt with drug addicts and tried to help them with their addiction and so on. This 38-year-old is a little bit heavy-set, but not particularly overweight. But he unfortunately had a heart attack. And he was at the hospital recovering. And one of his supervisors, I guess, was just speculating, how is it possible that a 38, 39-year-old man could have a heart attack? And he said, well, when a 38 or 39-year-old man has a heart attack, it's got to be cocaine. So he blurts this out. And somebody overhears it and says, oh, did you hear Joe does coke? Oh my God, Joe does coke. And on it goes. And pretty soon, everyone at the hospital realizes, oh my God, Joe's a cokehead. Well, he gets better. He comes back to work, and he suddenly discovers that his clients, who are the drug addicts who he's helping, are looking at him saying, why are you beating up on me over my drug addiction when you're a cokehead? He goes, what are you talking about? He goes, oh, everybody here knows you do coke. That's why do you have your heart attack, because you're doing cocaine. And he says, I don't do coke, I know what you're talking about. Well, anyway, this rumor, begun by his supervisor, gets all around town. People are looking at him like he's a cokehead. He suddenly discovers his neighbors and his colleagues, not only at work but around the community, aren't treating him very well. He was very proud of the fact that he was rising in the Masons, and he was kicked out of the Masons because they don't want a cokehead among the Freemasons. So suddenly he's a non-Mason. He then turns around and sues, and thus we find ourselves in court. The defense, which was handled by the what's called the Corporation Counsel, which is basically more or less the Solicitor General of New York City, comes in and defends the case. And they say, look, if we did such a bad job and he felt so injured, why is it that he didn't quit and file this suit 2 or 3 days after all this happened? He actually kept working at this hospital for another, I believe, 9 months or so before he finally left. So if he felt so injured, why did he show up at the office for another 9 months? And so this was the debate, and this is how this went back and forth. We finally went to the jury room and we deliberated, and we had 6 jurors in this civil case. And in New York City, you don't have to have a unanimous decision. It has to be 5 out of 6. So 4 people lined up with the city and said, look, there was no negligence in terms of making this statement about this guy being a cokehead. 2 of us were on his side and sided with him and said, look, this is a totally inappropriate thing to say. His reputation was ruined. Nobody should have said that. And he clearly deserves to be compensated for the loss of his reputation. And we debated for 3 days. We deliberated for 3 days. This went on a long time. I think we started like on a Wednesday and then a Thursday and a Friday. So we deliberated for about 3 days on this. And finally, on the 3rd day, the 5th juror, who was on my side, finally flipped. I think he had heard enough of the other side's arguments. He changed his vote, and then it went 5-6. We went in and told the judge, and the ultimate decision there was the jury decided for the defendant. There was no award to plaintiffs. He also walked out of the jury room with nothing. That was a very interesting, very tough case, and he saw no compensation for what he saw as injustice. So that was that case. Now this here may look to you like the winner of the 1937 Joseph Stalin Award for Socialist Realism Architecture. That, in fact, is the New York City Criminal Courts building. And it's been described by many people as the most Stalinist piece of architecture in New York City, and I'd concur with that. This is, if you go to criminal court in New York City, that's what it looks like. It looks a little bit less foreboding in color, but only a little bit less. So that's where the next case took place, in that building. That was a criminal case. It was a criminal case involving armed robbery. And the contention there was on the part of the victim, who claimed that he had picked up, he was a gypsy cab driver. Gypsy cabs are cabs in New York City. They're not official yellow cabs that are licensed by the city. These are much more informal. People drive their own cars, usually big cars. They'll pick people up and take them usually to parts of town where people don't really want to go. You won't see gypsy cabs down in Times Square. You will see them up in Harlem, out in Brooklyn, up in the Bronx, and so on. So this driver's driving around Harlem, and he picks up 2 guys, gets in the car with them, and he says, okay, according to the driver, they say to him, drive down this dark street. And he drives down the dark street. They say, stop the car. They put a gun to his head, take his money, run out the car with his wallet and his cash, and he's now been robbed. The driver immediately goes to the police department, says, I've just been robbed. He goes to the local precinct. They say, great, hop in a squad car. We'll drive around and see if we can find these guys. After about half an hour or so, they find these guys walking down the street. The cop goes out, asks him to stand by the wall. He goes back and asks the guy, the victim, and says, are these the 2 guys who robbed you? He goes, yes, those are the 2 guys. They cuff him, they take him in. So they then bring him into the courtroom, and we're then prepared to figure out whether they're guilty or not. The first witness in the case is the man who's been robbed. So he sits down on the witness stand. He doesn't speak English. I believe he spoke Haitian Creole, so we had a translator going back and forth. And after we learn a bit about him and his family history, how long he's been in New York, et cetera, the prosecutor says, sir, would you look around this room, please, and tell us if you see the 2 men who robbed you? He looks around, says, I don't see him here. Everybody, you literally hear everybody gasping. We all think, oh my God, this case is going to collapse right before our eyes, like that. And the prosecutor senses this too. And she says, sir, let me repeat my question. Would you please look around the room very carefully and see if you see the 2 perpetrators who you say robbed you. And he looks around again, and this time he stands up, and he notices, as he looks over the judge's bench, that elevated place where the judge sits, just past the top of the bench, he's able to see the 2 defendants, and he says, there they are right now. Whew. Okay, so the case then went on. So we all thought, all right, I guess we're going to be here for a few days. So the case went on, and the longer that the victim stayed on the witness stand, the more reasonable doubts we had. He said in his testimony that they were 2 gentlemen about the same height, The defense had them stand up. One is about this big, one is about that big. Their heights weren't even close. He said these guys are about the same age. One of them was about 35, one was about 52, so the ages were not the same. They didn't even look about the same age. There's also a lot of discussion of them, of the perpetrators wearing very bright green, neon green hats that they got at some event. And despite the discussion of the hats, the victim made no comment about the hats. And they brought the hat in, which was a big, big screaming green hats. And for him to have missed the hats, we thought was a pretty big detail to have missed. And so this goes back and forth. And one of the questions that was a big question in the case was, would the dispatcher at the police station, when he told the squad cars, be on the lookout for such and such a description, did that contemporaneous description from the police dispatcher match what the victim said he saw? And if the dispatcher's contemporaneous description matched what the victim said, we thought that gives additional weight to his description of what happened. And if they differed, then we would take his testimony less into consideration. And as she was doing her closing argument, the prosecutor held up a compact disc and said, as for that dispatch recording you've heard about, it's right here on this CD. And she puts it down on the table. So then we go and deliberate, and we had a lot of reasonable doubts. We start bringing these up. We said, the heights don't match, the ages don't match. What about the green hats? And back and forth, back and forth. And we said, if we could hear that recording from the dispatcher, it really would help. Maybe that would help us put some of these, connect some of these dots. So we sent a note to the judge, and we said, Your Honor, could you please, we'd love to hear that recording. Would you make it available so we can listen to it? And he said, let me instruct the ladies and gentlemen of the jury, that CD you saw the prosecutor hold is not in evidence. Would you please return it and deliberate? So we go back to the jury room and we say, all right, we've been played. That prosecutor is playing games with us. She's holding something over her head, which wasn't evidence. Motion to acquit. We all put up our hands like that. We sent a note to the judge, said, all right, we've just ruled. Would you bring us back in? We walked back in about 10 minutes later. By luck of the draw, I was juror number 1, so I was the foreman of the jury. So I was able to walk in and announce our decision, which was, your humble foreman announced defendants not guilty. So we really thought that we were played games with, and so we decided the fair and just thing to do would be to let them go. They looked a little shady to me, but somebody looking a little shady does not constitute a conviction. So off they went. So those are pretty much the facts on those 4 cases. What lessons can we draw from these cases? If you were in law school or you were sitting down here in the Trinity College Library in Dublin, where that is, what lessons might you possibly learn from these cases? The first is on the limited facts case, the Cousin Vinny case, as I described to you. The mere presence of a jury speeds parties seeing eye to eye. Those of you who are practicing attorneys may know this, but in this particular case, just the mere fact that, oh my God, we're about to go to trial, who knows what's going to happen, all kinds of legal fees are going to kick in, and ultimately this may go the wrong way. So hey, let's just sit down and cut a deal, whatever it is. I never found out the terms of that deal, what the arrangement was, but somebody decided, okay, we're playing chicken and 2 cars are about to collide, so let's go this way rather than that way. And the decision was made to end it all and send us home and not take that any further. So if you're ever in a situation like that, maybe what you really need to do is seat a jury, and maybe your opposing counsel will see things the way you want, or at least half the way that you wish that the opposing counsel would. Second, the medical malpractice case. Several lessons. One is appearance and presentation matter. In this particular case, you had one attorney who was the defense attorney defending the doctors in that abortion clinic situation. This attorney was smooth, polished, well-dressed, very elegant, lovely suits, much closer to the John Houseman paper chase model. And it was very impressive, just the way he spoke, everything else. The attorney representing the injured woman reminded me of Columbo. If you guys remember the old TV show, you guys are all young, you may not remember Columbo on NBC back in the 70s, played by Peter Falk. Worth looking up if you get the chance. Rumpled, disheveled, papers all over the place, shuffling around like this. Every time he started saying something, he began saying something, he says, let's strike, let's try again. And so always this stopping and starting as he spoke. And we just got the sense this guy was just not on top of things. And as we were deliberating, I think we all got the sense, one attorney kind of knew what was going on and had his act together. The other one was just kind of juggling it all, trying to keep the whole thing in place. And so maybe the guy who was better prepared maybe had a better grip on the truth and a grip on reality. And I think certainly unconsciously, maybe even a bit consciously, I think we weighed things more towards his side And we definitely had the thumb on the scale more because of his appearance and presentation. And so I think as you're thinking about how you're going to try cases, so on, that's something you ought to keep in mind. We had a discussion earlier about whether there's any prejudicial bias for attorneys who happen to walk into courtrooms with beards. So that's something maybe you want to think about. One way, whatever your decision is, you might think about that. Another lesson here is objects in mirror may be less connected than they appear. This whole business was the ultrasound machine. According to the defense attorney, it was purchased by the practice, so they had it available. What the plaintiff's lawyer had to prove to us, and he did not prove, was it was available, plugged in, ready to go. All these doctors needed to do was click on the on switch, and they would have had it available, and they could have done this procedure properly, and this woman would not have been injured. I think in the mind of that plaintiff's attorney, he'd been looking at this case for months, maybe years. He knew all the facts. He knew the figures, the dates, etc. And so in his mind, it was very clear where that device was, where that machine was. But he did not manage to put that information in our heads. So we had .A, .B, .C, .D, but he didn't put a string there to connect them all together. Had he done that, I think we would have said, look, the doctors had that machine. They didn't use it. They should have. We're going to rule on behalf of the plaintiff. We would have given that woman some money. He didn't manage to get that device out of the box and into the room in our heads. And so he needed to have connected those dots. They're certainly connected in his head, but not in our minds. And so as you're trying your cases and working on cases, you've got to remember that the jury needs to understand things that they're hearing for the first time that you've been grappling with for months or years, as the case may be. So try to remember that and try to make sure that all these dots need to be connected in a way that might seem totally redundant to you, but will be the first time these 12 important people or 6 important people are hearing these things, sometimes for the first time ever. As a consequence, practicing in front of a focus group or a mock jury or something like that is probably a good idea, even if it's a matter of bringing in 4 or 5, 6 associates, summer associates, and saying, look, we're going to do a little mini one afternoon version of this trial. What do you think? Does this make sense? What questions do you have? If it's a big multi-million or multi-billion-dollar case with a whole lot of money, you might want to go to the trouble of actually bringing in some people and paying them to sit down and listen to this for several days and make sure that all these dots are connected, that are connected in your minds, and make sure they're connected in other people's minds as well. Defamation of character case. Jurors can become very emotionally involved in cases and take the plights of parties very personally. I, for some reason, very much associated with this gentleman who was accused of being a cokehead but was not, and had his reputation damaged very badly, and I felt very sorry for him. And he seemed like a very sympathetic witness in the witness stand as he was testifying. And I felt very, very personally involved and very invested in this case. And so when ultimately it went against him, I was crestfallen. I was very sad. I went home that Friday afternoon, and I had a rotten weekend, and I didn't feel better for about a week. I felt really, 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 really upset about the way it turned out. And I felt terrible I couldn't have done more to persuade these people to see things the way I did. I felt like a failure because of that. And so it may or may not have any impact directly on how you try cases or how you behave in a courtroom or what have you. But just be aware that in some of these cases, this is just defamation of character case, how emotionally involved people can get. If you're dealing with mass homicides and all sorts of other things, it becomes even more rough. But if not for everybody, at least for some people, people will hear these cases, get involved in them, deliberate for a long time, and very much get their hearts and souls wrapped up in all of these things. That's probably something you ought to be aware of. The armed robbery case. Never tease jurors with unadmitted, quote, evidence, unquote. The moral of that story is if you're going to wave something in front of the jury, you better pray and hope that that is something that if they want to hear, that they can see and hear. If that had been evidence, we would listen to it, and if it said what we thought was on it, we might have convicted these guys. Instead, we very much felt played, manipulated, and toyed with, and as soon as we went back before we almost could sit down in our seats, we said motion to quit. And we said, let's get these guys back on the street and out of this system. So the prosecutor really blew it with that. She shouldn't have teased us that way, and that was a very, very bad tactic. And if you try that and you get caught by the jury, that very likely will blow up in your faces. So don't do that. Broad personal observations as a result of these experiences I've had. Runaway juries sit still and take their work very seriously. We've heard lots and lots about runaway juries sitting down, hearing a case, and basically getting into a bidding war in the jury room about how much money how much of other people's money they're going to give away to the plaintiffs and the plaintiffs' attorneys. In my experience, it may be different with others, but at least in my experience, that's not the case. What I found was juries sitting down and taking the evidence very seriously, taking the law very seriously, and not just sitting down and trying to figure out how much money we could put in people's pockets. And in fact, in that case, involving the personal injury, medical malpractice. One of the jurors said, after we decided there was no negligence on the part of the doctors, one of the jurors said, well, I feel sorry for her, we got to give her something. And every other juror said, no, that's not how it works. We don't just give money to people. Before she gets $1, we have to determine there's negligence. We don't see any negligence. We feel very sorry for her. We hope she gets on with her life, but she's not getting a penny out of us or out of this court or out of this system. So that was the experience I had. So there may be runaway juries that are busy handing out cash. I've not seen it in my experience. And people take this work very, very seriously, and I found that very gratifying in that regard. Secondly, jurors value the system, so it will be there for them. In all these cases, I heard over and over jurors saying, look, it's kind of a drag to be away from work. We've got things to do. It's not very convenient, but this is very important that we participate in this, because if something goes wrong and we get arrested or we get injured or we need to sue somebody, we want this system to be here for us. And the only way to make that work is for us to serve it as well. And so I think there's a real sense of civic duty and civic participation in that. And I found that very rewarding and very heartening. Third, jurors value and display dignity. This I saw, again, people taking very seriously what they do, expecting the other attorneys, the witnesses, and everybody else to behave in a very upstanding and dignified manner, incumbent with, or I should say, that coincides with the seriousness of the matter and the stakes that are at hand. We saw this, for example, in the criminal case. I was, as I mentioned, juror number 1, which is the foreman, sitting out of the 2 benches in the front bench closest to the witness box. And when we took our first break, we walked out of the jury box. I walked out in front, and then juror number 2 behind me, juror number 3, and we all kind of filed out in procession, jurors 1 through 12. And we walked out like that, did our lunch or whatever. And when we came back in, we lined up jurors 12 through 1. So we'd all walk in pretty much in reverse, not walking backwards, but pretty much in reverse order. And then juror 12 would sit down, juror 11, juror 10, and I would sit down finally as juror number 1. And we sort of developed this without planning. It just sort of fell into this routine of walking in one way and then walking in the other reverse direction. And I think all of us got the sense this was a small symbolic thing that represented how seriously we took this and how dignified we had to behave and how serious we were about the whole situation, the process, and the system. And this is something I've seen in all of these cases. The jury system may be the most functional part of our government. I don't know if that's good news or bad news, but in a country where it seems that the government can't get anything right, I mean, one problem after another disaster, after another expense, after more waste, fraud, and abuse, et cetera, and corruption, the jury system may be the most effective thing we have. Every day, coast to coast, hundreds if not thousands of juries hear cases and determine whether people will spend time in jail or go free. Will they walk out of the courtroom with thousands or millions of dollars as compensation for injuries, or will they walk out with nothing but empty pockets and possibly legal bills? People sit down and make these very, very important decisions on a daily basis, and generally I think it works quite well. So while the rest of the government falls to pieces, I think the jury system is holding up pretty well. We all should be grateful for that. The criminal jury remains a bulwark of liberty here in America. And this is something that I think we take for granted. We don't really think about the fact that if the government wants to lock you up and put you behind bars, unlike a lot of other countries, they just pick you up and drop you off and leave you there until they decide it's time for you to go. Before the government can do that in this country, they need to persuade 12 of your peers that what they think you did, you actually did. They've got to present evidence, and they've got to persuade all 12 of these people who've never met each other before, who have no connection to the juror, who said publicly that they can be fair about this, that they believe the evidence that the government is required to serve as the government having the burden of proof, and therefore this person is guilty and this person should go away for some time. We take that for granted. We shouldn't. We're very fortunate that we Americans have that tremendous bulwark standing between us and people in the government who might think it'd be really convenient to put somebody off in a corner behind bars for a short period of time or a long period of time. And they can't get away with that unless they can convince 12 randomly selected American citizens that ought to be the case. And we ought to be very fortunate and thankful for that. Last but not least, it is a high honor to be a juror, so do your jury duty. I have been very pleased and honored to be a juror. When I get my request for service in the mail, I don't hide or try to run away. Sometimes the date has been off and I've said, hey, I'll come back in 6 months, but please call me then. And I show up and do my jury duty and encourage other people to do it. I found it rewarding. I found it interesting. It's always fascinating. I've learned from it. And I always walk away feeling better about the system, better about the way we administer justice in this country. and very gratified to have had the opportunity to participate in something that helps keep us free and make sure that we, in addition to liberty, we enjoy justice in this country. So when you get that in the mail, please do your jury duty. It's a good thing, it's a positive thing, and it's one of the things that makes us very lucky to be citizens of the United States of America. Thank you very much. I'll be happy to answer questions until I'm told to stop.
Deroy, in your criminal case, did the defendant or defendants testify? And if not, did that come into play? I know the judge the judge instructs you not to take any inference from that one way or another, or that you can't take an inference from it. But did the defendant testify?
No, the defendants did not testify. We didn't hear a peep out of them. They're perfectly quiet. I think at one point somebody said something like, I really wonder what these guys would say, and everybody else said, well, it doesn't matter. They don't have to prove a thing. It's made very clear to us in voir dire as we're waiting to hear to be seated or not. The defense attorneys say our clients don't have to say a word. It's up to the government to prove they're guilty. They can sit here in total silence, and if the government does not prove its case, they walk. So would it bother you if they in fact do not take the witness stand? And everybody understands that they don't have to. I think at one point it briefly came up, and the response was, yeah, they don't have to say a word, so don't worry about it. And it went away very quickly.
Did they give a statement to the police, or did they invoke their Miranda rights?
Good question.
And if they did invoke it, did that come into play when y'all were
I don't know. As I recall in that case, they didn't testify, number one. Number two, I don't think we ever heard anything they said to the cops. I think we knew that they said they weren't guilty. We knew what their plea was, but I don't believe we heard anything about their specific statements or lack of statements to the police. I don't think that ever came up. Yes, sir.
Science tells us that the human brain has a problem understanding negatives. So,
You don't say.
so if I tell everyone, okay, do not think about a zebra. Do not think about a zebra right now on the Serengeti plain eating some grass. Don't think about that at all. And yet, at the beginning of a trial, we will tell our juries, don't consider and don't begin to formulate your opinion until you've heard all the evidence.
Mm-hmm.
So basically, we're subverting the jurors from the beginning. And the jury research tells us that basically, by the end of opening arguments, the juror pretty much knows how he is going to find at the resolution of the case.
Mm-hmm.
And I was wondering, can you remember at the end of opening arguments which way you were leaning, and whether at the close of the trial that's how you eventually wound up voting as a juror?
That's a good question. I think in those cases the situation is ambiguous enough, so I didn't have a strong feeling one way or the other. Certainly a defamation of character case, I had no idea about that. I think in the criminal case, I will say this, back to the appearance question, the defendants looked a little dodgy. And I thought, these guys look a little shady. Who knows? Maybe they did it. I can tell you there was one case, which I didn't mention, I was not on the jury, which was a case involving a defendant who was being brought in on charges of cocaine trafficking. He looked like an extra in Scarface. I walked in, even before I sat in the jury box, I thought, oh, this guy's so guilty. I thought, don't think that. Now, as I recall, they didn't bring him in a suit. I think he was actually wearing his prison garb, so that didn't help. And during the voir dire, the question came up, Mr. Murdoch, do you think you can render a fair verdict in this case? I said, I don't think so, Your Honor. He said, why not? I said, well, I'm a libertarian. I don't believe in the war on drugs. And he said, do you mean if the prosecution presented its case, they'd be doing so with one arm tied behind their backs? I said, well, Your Honor, with at least one arm tied behind their backs. I said, all right, well, you're dismissed. So off I went. But if I'd been on that jury, decided to stay on that jury, it would have been a little hard for me to get past the way this guy looked. In terms of the statements or what the lawyers said, less that. But I can certainly tell you that the appearance of the people in court, at least to me, had a strong bearing. So if you are doing criminal defense, I would suggest you get your defendant to look as cleaned up and looking as much like the president of the Chamber of Commerce as possible. That probably would serve you well. Other questions? Back there, sir.
Do you feel justice was served in each of those cases?
That's a good question. Was justice served in each of those cases? Yes, I would say. Well, no. In one
I
of
realize you may not have agreed with your fellow jurors on one case.
yeah.
But do you feel it was a just decision by the jury?
Let's see. I think in the In the medical malpractice case, that was appropriate. I don't think the case was proved. In the defamation of character case, I really think that guy should have gotten. I think he really had his reputation harmed, and I think the jury went the wrong way, and I feel terrible at it. I think in the Cousin Vinny case, again, that was settled, so I assume that something just happened out of that settlement. And then in the criminal case, again, I think that there were reasonable doubts to begin with, very serious reasonable doubts. And then when we saw the government basically trying to cut a corner and fool us, we blew the whistle and said, sorry, you guys are done. And so I think that was just. Yeah. Sir.
We have so few defamation cases in my practice. The issue about the intention of the falsehood, the willful and malicious part of the publication of the falsehood, did that play into your case?
Good question. Intention versus the impact of it. Certainly the impact did. I mean, if this had been just the gentleman's, the plaintiff's supervisor saying, I think it was cocaine, and the other saying, that's interesting, and it stayed just among the top 2 or 3 supervisors, and it did not affect his promotion or his pay or whatever, I think it would have been a little hard for him to have gotten any of us concerned that there had been any damage. But when he heard about his clients laughing at him, saying, you have no right to tell us about addiction, number one. Number two, getting kicked out of the Masons, I thought that was very serious. The harmed his reputation outside. In terms, I think, was something that we all considered serious, although ultimately people thought that the fact that he stuck around and kept working for 9 months sort of obviated all that.
The law, as I understand, is libel and defamation per se, which just saying it creates liability. Calling someone a thief, for example, that has automatic consequences. Accusing someone of a criminal act, I don't know what the law is in New York, was there a charge of the jury as to whether or not it would be defamation or slander per se when someone charged someone of a crime as opposed to saying they were a nasty person?
Interesting. I don't remember that specifically being at play. I think it was more really revolving around damaged reputation, as opposed to, if they'd said, I don't know, did you break the law and therefore that is what made you harmed your reputation, versus someone saying, oh, you're a total alcoholic. It's not against the law to be an alcoholic. But if he'd said that damaged reputation, I think, would have been at play, versus so much that you're accused of breaking the law. That I don't think was quite as.
You're starting so much with the damage done. In the other cases, a question about liability first, then damages. It seemed like in your defamation case, you got the damages before you got the liability part.
I think so. As I remember the case, we spent a lot more time focusing on whether the damage merited or did not merit the claim that the plaintiff was making. Much more so than, he was accused of breaking the law. He was accused of a crime. I think we're less concerned with that than we were, did he really have his reputation harmed as much as he said? And if so, if he felt so damaged, why did he keep showing up to work for 9 months? If he had gone through all that damage and left in a state of humiliation and not come back to work, I think the jurors who were resisting giving him ruling on his behalf would have been much more sympathetic.
Did you find another job?
I don't know. We never found out. It's very interesting in these cases what happens next. You walk out of the courtroom and these people become a part of your past. Unless it's a famous case, these were not famous cases that got in the press, and so I really don't know what happened to these people afterwards. Quinn.
You came down very strongly in favor or very complimentary of the jury system and of your fellow jurors. Did you find any evidence to the contrary? Did you find any jurors who you just thought these people are either really dense or they don't take it seriously, or how can they have missed such an obvious thing, or how can they not? Did you find any juror that really made you doubt the system?
That's a good question. I don't think in terms of intention. I got the sense from everybody involved, this is serious. We've got to do the right thing here. Other people's, not lives, but certainly property and reputations and finances were at stake. Liberty, certainly, if we locked up those two guys accused of armed robbery, they would have gone to jail for a while. Everyone is very serious about this. I do think some jurors were brighter than others. I think some of them asked a couple questions that struck me as a little bit, like they weren't thinking too deeply. But I got the sense that with everybody, they were trying to do the right thing. They took it seriously, and they wanted to have an outcome that reflected the seriousness of our deliberations and the seriousness with which we took what was going on. That much I got. I'll come back to you in a sec. Let's see if anybody not asked a question yet. Did you ask one yet?
I have not.
Okay, and we'll come back to you. Go ahead.
My jury duty experience from the judge warned us, it was the DUI case in Bayonet, and he warned us pointedly to weigh the evidence as a whole, not piecemeal, and to decide beyond a reasonable doubt. We got in there and we started deliberating. We were tempted, not all of us, but most of us were tempted to do just exactly the opposite. We looked at each piece of the evidence, and there was a temptation to weigh, to decide beyond a shadow of a doubt, not beyond a reasonable doubt. The only people that voted to convict, and I think most people are soft-hearted and don't want to convict in a DUI case, were this lady and myself, because we did what the judge asked us to do, and I said, look, I think we're doing just exactly what the judge asked us not to do. And we had several votes, and we wound up turning the jury around and convicting. The judge came in afterwards and said, I'm not supposed to, I couldn't tell you this before, this man has been convicted 4 other times.
4 other times.
Yes.
He told you after the decision?
Yes.
Oh, that's interesting.
So, and said, you all did the right thing, and I appreciate it. Now, is it your experience that well-intentioned people don't want to do the hard thing, and is it your experience that people are tempted to decide beyond a reasonable doubt, or beyond a shadow of a doubt, as opposed to reasonable?
Interesting. I don't think I saw any sort of over-analysis of evidence, if you want to look at it like that. I don't think I, in my 4 cases, experienced what you described, or at least the 3 where we deliberated. I don't think I saw that. I've heard cases on the outside that in some cases, black jurors, and I think in particular black female jurors, very often will be reluctant to convict black male defendants. And the thinking is, do we need one more black man behind bars? We want one more man in our community, not to be there, being a good dad, being a good role model, being a good neighbor, whatever, but instead, breaking rocks behind bars somewhere. And therefore, let's not lock him up unless this person's, got blood gushing down his arms or something like this. I've heard that in other cases as a social trend. I can't say that I've experienced it personally, not in these cases anyway. You had another question?
Yeah, in Alabama, I think you have to have a driver's license to be picked as a juror. I guess Judge Bishop can speak to that. In New York, is there some criteria?
You need a subway token.
Okay.
We don't drive up there.
How do you get a pool?
That's a good question. How do you get a pool? I think they take it from, I don't know exactly, but it's not driver's license records because a whole lot of people in New York City don't drive. Most of us don't drive. I really don't know. I don't know exactly where the pool comes from. Somewhere they got a list, I think maybe voter rolls for starters, but I'm really not certain where it comes from. I should know that, but I don't. I'll try to figure that out, and next time we'll be able to let you know. Did I see a question back there? Yep.
As a juror, when you were deliberating these and your fellow jurors were deliberating these, you had been instructed by the judge on the law, and I assume up there typically there's an instruction here from the judge also don't forget, rely on common sense as well. As a juror, was it your experience that there was a lengthy look and discussion by the jurors as to the letter of the law, or was it more weighted towards everyone using their common sense?
Interesting. What were you looking at, the law or common sense? I think a number of times.
Just a good balance of the two.
I would say 3 things really. I think common sense to a degree. What does the law say? 4 things, as the list gets longer. Common sense, what does the law say? What did the evidence say? And what did the juror instruct us to do? Judge, what did the judge instruct us to do, I should say. And different people at various points would say, all right, well, blah, 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 but the law says this. Or someone would say, okay, the law says this, but here's what the evidence shows us. And someone would say, oh, that's interesting, but the judge told us not to think about that, but look at this instead. And at some point, somebody would say on certain things, well, yeah, right, all that, you think that, but obviously if we had an elephant run through the room, you'd notice the elephant, wouldn't you? So people would make appeals to common sense from time to time. I think so, yeah, I think so. I think people, in my experience, people look at all those four things, I think. Maybe not 25% each, but I think they were all part of the mix. Mm-hmm. Yeah.
Just curious, in New York, did you get to take a copy of the law into the deliberation room?
Did we take a copy of the law into the deliberation room? That's a good.
You were instructed by the judge, did he allow you to take?
As I vaguely recall, I think there were a couple of instances where we actually had copies of. We certainly had a charge sheet from the judge saying, think about this, work on that, focus on the other. With certain questions, we had to answer the questions, and based on the questions, we then would decide guilty or not. I think in one of the cases, we did have a copy of a statute. I don't remember very, very clearly right now, but I think somewhere in there we did have, if not the whole statute, at least a couple relevant passages, I think. I believe so. Ma'am, do you have a question?
Yes, I wanted to ask on the one that you, for the defamation of character, when it only had to be, what, you said 5 out of 6?
The 5 out of 6 decision would be decisive.
You were the only holdout for it because you believed the guy had been, his character had been damaged.
Yes, he'd been defamed.
Yeah, all right. If the other guy, if it had to be 6 out of 6, do you think you would have, somebody could have changed your mind, or were you going to stand by how you believed no matter what?
Oh, that's a good question. I would say after 3 days, I didn't see anything that would have changed my mind. I thought this guy had been damaged very badly. I felt terrible for him. I thought his boss, when he thought that, should have kept his big mouth shut. Shouldn't have said that. I did think it was interesting that he stuck around for 9 months. I would have felt even more strongly that he walked out right away. But ultimately, I think his character was defamed as evidenced by the way he was treated by his colleagues, by his patients, and ultimately by people in his community. So I don't think. Thank you. Well, I think if it had to go 6 out of 6, it would have been a hung jury. Yeah, so I don't think they would have flipped me. As Quinn knows, I don't change my mind very often.
Let me ask you, suppose, about maybe an attorney inadvertence, the judge would not have excused you to make that jury. Do you think you could have been a situation where you would have had your oath to follow the law as instructed by the court versus your personal belief? How do you think you could have ruled?
You're talking about the
cocaine case?
The son of Scarface case?
Yeah.
That's a good question. I actually, as I was sitting in the jury box during voir dire, as I say, I think the war on drugs is a disaster.
You put it close to the vest.
Right.
And if no one asked you.
Yeah, exactly. Well, I thought about, as we're going through the room and it's getting to be my turn, I thought, here's my opportunity to do my small part to fight back on the war on drugs, which is sit in the case, listen to all the testimony, and when we deliberate, do everything I can to get the guy out and acquit him. And I thought about that, and I thought, well, that's not really what I'm supposed to do. I mean, if I want to do that, what I should do is go home and write an op-ed piece on why the war on drugs is a terrible thing, why we need to put an end to it. My job, if I'm a juror, is to listen to the evidence, listen to the judge's instructions, and be as objective as possible, and then based on that, either lock the guy up or let him go out and have lunch as a free man. And so I thought, rather than kind of carry my advocacy position into the jury room, what I should do is indicate that I couldn't be objective and get out of the jury box and let somebody else sit there who could be objective. But I did think for a while about doing that, which is sort of a jury nullification from the beginning kind of policy or approach. And I thought it was tempting, but not the right thing to do, so I didn't do it. Yes, sir.
The rule in New York concerning the juror seat number 1 strikes me as curious. In Alabama, our juries get to elect their foreman.
Mm-hmm. Yeah, I think Matt mentioned that.
Usually it's a larger personality who will be a group leader. And I'm wondering, in the New York system, it seems as if the seat kind of vests the person with a certain amount of authority, and whether it was your experience, whether the foreman became group leaders not through force of personality, but because they were, in essence, baptized by their chair.
That's right, baptism by chair, baptism by wood. That's interesting. I think a little bit of that. Yeah, I think because it is a random thing, it's not always the person who's the student body president who's going to end up as the foreman, let's say. And I do think just by virtue of having the name foreman attached, that the person who randomly ends up in that position, who comes in after lunch says, okay, folks, back to work, or okay, we have a question, I'll write it down to send to the judge. After a while, that person just begins to take on a certain level of authority, just because the title is attached to that person. I'm not sure we became totally deferential to everything that foreman wanted to do, but to a degree, people would say, all right, the foreman's talking, let's all shut up. The foreman thinks this, let's give it some consideration. So yeah, I think just by baptism by chair, they do take on a certain amount of authority, and to a degree, people defer to that. Or if not defer to, at least respect that authority. I think you could put it that way. It is interesting that we do it baptism by chair, other people elect. I don't know if it's majority one way or the other, but interesting that we do it that way in New York.
What about the sidebars, when the attorneys approach the bench outside, they hear something of the jury? Did anybody comment on that or be annoyed by it?
Oh, was anybody annoyed by this? I think
or this attorney objected too much, things like that maybe irritated the jury.
I think there was some comment about, why all the sidebars? What are those people saying among themselves and so on? It'd be nice if we had a microphone there so we could listen in. But I don't think it's anything we consider too heavily, like, oh, that person did too many sidebars, so let's vote against him. It wasn't ultimately a decisive factor, I would think. Quinn?
Would you say, though, in this, you said a little bit about this because you talked about how appearances matter, but more broadly, not just appearances, but how big a role do you think the attorneys played in your overall impression of the case? In other words, if you had just had an automaton as a jury, as an attorney, each time, would the facts and the evidence, the law, have led you to the same place, or did it really matter how well the attorney did his job in presenting the case?
That's a good question. Did the attorneys earn their fees, I think is what you're asking.
Yeah, or do the opposite and turn you off.
Or turn me off, right. I would say that certainly in the criminal case, this business of waving this CD around, we were disgusted. I would describe it as disgust. That was bad lawyering, and she shouldn't have done that. And we felt particularly, it'd be one thing if you're a defense attorney, but if you're the government, which is what the prosecutor was in that case, for the government to be waving around fake evidence in quotes, and trying to get us to be persuaded by that, we thought this is a completely inappropriate government behavior. And instantly we said, let these guys go out. These guys need to walk out the door as free men, boom, just like that. So I think in that case, yeah, the quality of the attorney's work in that case made a big difference. I'd say probably in the defamation of character case, I think that the attorney for the plaintiff actually was a little bit comical. He tried to do a few things that I think he thought were funny. At one point, he literally did like this, and did a Three Stooges thing, just like that. They did, literally, and he goes, woo, like this. I don't remember why, but he did that. I think it was him giving us a sense of how completely out of control the Harlem Hospital administrators were. I think he was referring to them as the Three Stooges at one point. In the jury room, some people thought that was really undignified and really silly. Why was he doing this? And some people were offended by it and thought that wasn't funny. This is not a comedy routine. Why is he behaving like that? So that's one where that probably cost him some points, I would think. And then in the medical malpractice case, I think again the lawyering, the presentation. If it had been an automaton presenting the case rather than Columbo, as I described it, I think in that case, even the sloppy presentation. It was not just the presentation, but the fact that he was unable to connect the dots and put that ultrasound machine in the room.
What you're saying is the attorney's work really does make a difference.
Yeah, yeah, I would think so. I think it does. Yeah. So if you need an attorney, get yourself a really good attorney and pay him a lot of money, lots of money. Make sure you get yourself a Federal Society attorney too, the very best kind you can get. Is that our signal that it's time to go?
No, that's the shift to Obamacare now.
Oh, I see. That'll be another 4 hours. If there's a question about Obamacare, I'll try to answer it.
Well, I've got one.
Okay.
The Affordable Care Act, right?
Yes.
AKA Obamacare. how much do you think that'll add to inflation, the rise of inflation? You know, that and you think about the raise of minimum wage and the overtime provisions that I guess there's a definition change there. And I'm concerned that we're going to have faster rising inflation than people realize and how that can contribute to it. Have you thought about that?
That's a very interesting question. I've heard many objections about Obamacare, but I think you're the first person ever to raise the prospect of its inflationary capacity or tendencies.
Well, all of the cost of labor equates to cost of goods, right? And producing the cost of goods.
Yep. No, I think you raise a very interesting point, and it's one that makes me want to look into it even further. There are certain aspects of it that definitely are increasing costs. I mean, certainly the increase of having to cover your employees at whatever point the employer mandate kicks in. It keeps getting pushed down past the 2014 election, past the 2016 election. So I assume at some point in 2017, if the employer mandate ever fully kicks in and people's labor costs go up, what do employers do with labor costs? They pass them along to their customers. So I think that is going to be inflationary. We already have the medical device tax, which is increasing the cost of medical devices. In some cases, medical device companies are responding by moving out of the country. I think some of them moved to Costa Rica. Some of them have fired people, and I think some of them continue, but they just pass along the cost of the tax to their customers. That's probably going to push costs up. So I think you raise a very good point. I don't know. Inflation, fortunately, has managed to stay low. I think in part because a lot of money is sitting on the sides. We've not had the velocity of capital that you'd see if we had a thriving economy. I guess that's one of the good things about a slow economy is the inflation hasn't had a chance to kick in. But I do think that you raise an interesting point. I think that Obamacare probably will have at least a marginal inflationary impact, and not for the better.
That 3.8% tax that's hidden in Obamacare could be important for people making what, over $250?
Yeah, there are a number. One is if you make, I think it's more than, it's a little higher than $250. I think it's closer to $400, I think. If you're married, if you're single, it's around $275 or $300 maybe. I think there's a 3.8% increase in the tax on Medicare. I believe the ceiling for that has been pushed up. I know that your capital gains exemptions start to evaporate at that point. There's also if you're an employer, there's a per employee tax. So I think it's $65 or $68 a head. That sound right? That ring a bell? Somewhere in there. So if you've got 1,000 people, you're going to pay $68,000 as an additional payroll tax, essentially. I mean, all these things kick in, and what most companies do is, unless they're in a very, very super competitive market and absorb these costs, they just pass them along, and we, the customers, get to enjoy them.
Yeah. GDP's not growing. You know, it's kind of struggling along. Velocity of money's falling, declining.
Mm-hmm.
And, you know, I could see how you could have inflation and still have GDP not performing. And I suspect that...
That's stagflation, basically.
Yes.
Yeah.
Stagflation.
That's called late 1970s.
And I suspect that there may be some changes in the way the Fed goes forward, because the quantitative easing has done a lot to help big banks and the values of real estate. It's done nothing to help GDP that I can see. I mean, it's just bouncing along.
Yeah, the GDP's crawling forth at 2% and change.
The thing is that the money, banks got excess reserves by giving mortgage-backed securities to the Fed, and they're not loaning that money.
That's right.
The essence.
There's a very good TV movie called Too Big to Fail, which was done on HBO a year and a half, 2 years ago, directed by, I think his name is Jay Roach, if I'm not mistaken. I think he directed the Wayne's World movies. It's a very good and pretty amusing movie about the whole economic meltdown of 2008, and Hank Paulson, our Secretary of the Treasury, coming in and telling the banks, okay, you've got to take TARP money and all this other stuff. And some of the banks said, look, we're a healthy bank. We don't need welfare from the government. And they're told, all right, if you don't take this money now, because we want all the banks to take the welfare together, don't come to the discount window and expect any help from us. So they all took the money. In the very last scene, you've got William Hurt, who plays Hank Paulson, and Topher Grace, who was in, what was that show? That 70s show. He plays his assistant. And in the very last scene, they're in the Treasury building looking out at the National Mall, and the young assistant, Topher Grace, goes up to Hank Paulson, played by William Hurt, and says, wow, boss, that's amazing. We finally got all these banks to agree to take the money. Do you think they're going to lend now? And William Hurt says, Hank Paulson, oh, they're going to lend. Believe me, they're going to lend. It's just at the end, roll credits. Boom, that's it. Hilarious. So here we are. It's 6 years after that. And we're still waiting for them to lend. It's amazing.
They're reinvesting in treasury.
They lend it right back to the government. It just goes in a nice big circular, hermetically sealed circular loop. It's amazing. I think we have time for about one more question. We should wrap it up. Yep.
As a juror, were there any actions or behaviors or things you observed that the judges on any of the cases did that you felt were either may have shown bias or you felt were not proper, or something that you felt may have guided the jurors to a different decision than anything they did as far as their behavior rulings or anything of that nature? And I ask that because as a judge, you want to make sure you're not doing anything to improperly influence the jury. It's the jury's decision, not the judge's. And so, I'm very interested if there were any, since you've had 4 cases that you sat on, were there any of the judges that you felt, did anything that maybe they shouldn't have, or that you felt in some way influenced beyond what their role was?
That's a good question. Did I see anything on the part of any judges that I thought was in any way inappropriate or might have swayed the jury? The only thing that comes to mind, I don't think ultimately swayed our decision one way or the other, but there was one judge who, from time to time when he thought that we were not getting the information out in testimony, rather than let the attorneys question witnesses, would jump in and start asking his own questions. And I remember sitting there thinking, okay, well, why don't you just let the prosecutor ask the witness, or let the defense attorney ask the witness questions, and the judge was jumping in and asking questions. It's almost like it had three sides on this two-sided case. So I thought that was kind of distracting and kind of pushy on his part. I can't say that we learned anything from that or were deprived of any information because of that led us to come to a different decision. I do remember thinking, wow, what a pushy judge. I did think that. So that's about it. I can't say that in any of these cases anybody thought, well, this judge kept something away from us or said something or threw things one way or the other.
Well, one final question. Jurors used to be the judges. When you had 12 people, they actually would ask the questions. Did you ever feel like, ask this question? What ask?
Oh, yeah. Oh, sure. Absolutely. No, I mean, and this is something, I don't know if you guys do this, but I found many times I watch various events on TV, either press conferences or congressional testimony or whatever, and I think, somebody asked this question. Somebody please say, why isn't anybody asking this? And you yell at your TV. And of course, the people inside the TV never do what you want them to do. So there were some instances where it's, all right, well, there's an obvious next question, and how come we're not hearing it? So to some degree, there's some of that. But given my personality, I probably shouldn't surprise you that I'm a mindful of questions, and always fewer questions that are actually being asked. I think we're about to wrap it up. So let me say thank you very much for your attention. I enjoyed this very much, and I hope to come back to Mobile very soon. And in the meantime, that's where I am if you care to find me. Thank you very much.
Thank you. That was very good. Thank you.